Hello, it's Attorney Mike Gravel coming to you from Chicago as usual, and Eric Martin is still in jail. Oh, yes. He just can't seem to get out. I don't think he wants to. But we've got some fun stuff. The usual suspects are involved. Zach has done a lot of the heavy lifting. Brecken gave a hand. And Alyssa, let's do this thing, shall we?
Do you have a little window, like a little thing that opens and closes the window for your camera?
Here you go.
Oh, here we go. There we go. Okay.
Sorry about that.
No worries. I'm getting tech support tonight.
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Tarrant on behalf of Mr. Martin, who appears. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as by Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled it out.
He's also been known as Big Dummy.
Capital letter his name.
Yeah, you're Eric Martin.
And by several other variations that I can't say here.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Oh, okay.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now. And under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he's told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Hello? Am I heard? No? Hello?
Yeah, do we have the prosecutor available on this matter?
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
Wasn't there a contempt in there too, though? I don't know how all that works, but I would think that would have an effect.
He's in the main session now, Judge.
Okay, so what I got to say then, before the prosecutor gets a chance to say something?
So, yeah, this is on the Eric Martin case, charged as a misdemeanor domestic violence, originally
point.
placed on a personal bond. My understanding that he violated bond and the bond was reset at 2,000 cash because he violated, I think, by having, I think it was, correct me if I'm wrong, contact with the victim.
Judge, Alex Springer for the people, P9P 865. Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to. He's not allowed to go to.
So, yeah, and so, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now, it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
You have something to say, Your Honor?
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Yes, Judge, the people.
Let's hear from Big Dummy. That's more fun. The prosecutor's going to just sit here and say something reasonable.
The victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right.
I would also ask that he be restricted from wearing these shoes.
Yeah, did you want to be heard, Mr. Martin?
Yes, okay, now, I want to add, under, not only should, before we get to the bond issue, the case should be dismissed, which I did file a motion to dismiss already. The court probably just received it, because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C, 1 through 6.
Oh, I think he knows. I think that's a big part of what's going on here.
6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on violation of my speedy trial right. And based on the court rule I just named off, I'll say it again, case everyone heard clearly. MCR 6.004, subsection C, 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not the normal excluding Saturdays and Sundays and legal holidays. That's always been followed wrongly, but it's not, like I said, it doesn't apply to speedy trial. So my right to speedy trial has been violated, the case should be dismissed. So I want that decided on first before we address the bond issue, because as long as that's granted like it should be, then the bond's no issue. But so once the decision's reached on the motion to dismiss, I just filed now. Then once the decision's on that, then I'll address the bond if it's not granted. But that's all I have to say on that for right now.
Okay, let's address the motion. Denied.
Yeah, Mr. Randall?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been, I believe this is the third or fourth defense counsel representing the defendant, and if it would be then in the court's client to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels. And once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged and addressing bond again, that if the defendant is released on personal bond, it's put on a tether.
I gotta talk to.
Okay, now, what he just said was, I was gonna say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December is when I was arrested by Taylor Cops illegally, based on no evidence, based on my brother's lying allegation that I sold him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court ruled again, NCR 6.004, subsection C, 1 through 6, makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands the case, calls for the case to be dismissed. Simple as that. Everything else the prosecutor's saying is nonsense.
I'm in this video and I don't understand how I got put here.
All right, we're going to put you on mute, Mr. Kerr. This isn't.
Imagine the confusion for some guy who just clicks in and ends up in a video, and it's the Eric Martin hearing.
This isn't your case at this
I'm
time.
supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right,
Hello?
so thank you. Yeah, who's speaking now?
That's the victim.
This is Kurt Martin, the brother,
All right, did you want to comment on this whole matter at this time, Mr. Martin?
no, I mean, no. I couldn't even I didn't even know it was today, the court. Thought that it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and so I don't have nothing really to comment about. I mean,
All right, very good.
Oh, sweet Jesus. What?
I just want to make sure that you can see me and I was heard, because there's nobody that see me or something.
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be, to a great measure, caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied. I will allow a personal bond in the case of $2,500, conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're going to need an address for you or phone number, Mr. Eric, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now. Can I make objections now to your order?
I did not hear that.
I said I have objections to your order. Now, first of all, in objection to your order, no delay is being attributed to me switching attorneys. That's false. Okay? I have not intentionally said, give me this attorney over that attorney. Whatever they did, that's their, what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house I've been living at for 32 years. The house I've been living at for 32 years, regardless of whether it's mine or not, okay?
Do you
Based on an
understand?
unsupported lie.
I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions? Is
That's
that what
right,
you're
because I have no other house to go to.
All right, Mr.
I have no other
Martin.
house to go to. And it violates my due process anyways.
Yes, so Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated
That's false.
he won't comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next pretrial conference. Same bond conditions. And
That violates my due process. I want to appeal this now. I want to appeal this to the Court of Appeals ASAP. It all violates my due process. It violates my.
All right, thank you. That's going to end the hearing.
Just cut his dumb ass off. I want to feel it ASAP. Big dummy, we call that instanter in court. But here's what we've got. Alyssa claims to have a video emergency here. She won't tell me what it is. But I'm trying this, okay? If it sucks, you can blame her.
This is Jonathan and Mary Kay Borsch Family Foundation et al. Versus MD Industries LLC et al. Docket number 22-202CB. And this is the time set for the receiver's motion to have a continued date and time for the show cause hearing, which is indicate for the record that because of Mr. Doherty's disruptive outbursts in the courtroom, we are conducting this hearing on Zoom only. However, it is completely accessible to the public. Mr. Doherty was provided the Zoom room number and he is in fact here. We are also streaming it to the media room right down the hallway outside the courtroom in case anyone else showed up in the courthouse to view this. And I'm also live streaming on my YouTube channel right now, and that live stream will remain up for anyone to view. And as I indicated, Mr. Doherty is present, Mr. Polderman is present, and Mr. Polderman, this is your motion, go ahead.
Thank you, Your Honor. Good afternoon, John Polderman, court-appointed receiver. This is my motion and incorporated brief to continue the show cause hearing. As the court has noted, back in April, I believe it was April 4th of this year, the court set a date and time to take up the criminal contempt, or for Mr. Doherty to show cause as to why he should not be held in criminal contempt. However, before the court could take testimony or conduct that hearing, there was an outburst by Mr. Doherty. He was sentenced to incarceration. He's since been released and is here today. However, I am seeking that those hearings be continued. I also cited in my brief the case of in re contempt of Murphy, which is a recent decision that I also attached as an exhibit, that if there is a summary criminal contempt and incarceration that doesn't meet the test for double jeopardy, and the underlying contempt proceeding can continue. So I am seeking a date and time for the continuance of that. I understand that it would be remote and over Zoom, but I believe there needs to be a hearing on the emails that were sent to numerous parties and a decision made on the underlying motion. And obviously, Mr. Doherty is entitled to either represent himself or have counsel and prepare for that hearing. So I'm just seeking a specific date so the parties can prepare accordingly.
All right, thank you. Mr. Doherty?
Yes. First of all, how long have you known Mr. Polderman and Simon PLC, Ms. Dragonchuk?
I'm not here to answer your questions. This is your opportunity to be heard in response to the receiver's motion.
So are you failing to disclose your prior relationship that may affect your ability to rule impartially in the matter here?
If you wish to forfeit your opportunity to respond to the receiver's motion, I can mute
I'll
you,
take
but
that as a
otherwise,
yes.
here's your chance.
No problem. Okay, so first of all, that hearing on 4-4 was designed around my respectful and meeting with Ann Krupp of the title company, of which I personally owned that house. I paid for it out of my personal account. Therefore, my wife is still owed approximately $300,000 based on marital property rights alone. And I have been very disappointed with Mr. Polderman of Simon PLC and the way he just literally makes up stories. I've never even imagined that this could actually go down in a courtroom, Ms. Dragonchuk. And I have said multiple times, I don't know how many false pretenses, false statements, examples of perjury, deceit with intent to harm I have witnessed firsthand from John Polderman of Simon PLC, who has been illegally connected with the plaintiff's attorney behind the scenes. This has just been a miscarriage of justice, to say the very least. And I am again asking you respectfully, as I was before I was illegally put in jail. Everybody, you know, Mr. Polderman, you hear he's just trying to say outburst. The definition of outburst is similar to a volcanic eruption. And I want everybody to go through and actually see firsthand for my actions and my words, which were respectful and professional. But I was simply asking you once again, Your Honor, which I address you as that out of respect for this courtroom, but I truly do not feel like you are capable or impartial enough to be able to, even remotely consider true justice in this matter. And my case hasn't even been heard. I continue getting silenced and suppressed. I had two terrible law firms that did not do much of anything in the way of combating these white collar criminals. Therefore, I've taken this in my own hands, and I have done so respectfully. I've done hundreds of hours of research, and at this point, I know what I'm talking about, and I know what true justice looks like, and I know the opposite of that, which is this very thing here.
All right, thank you. First of all, going back to the hearing that we had, Mr. Doherty was anything but respectful. It was a volcanic eruption of sorts, and it happened the moment that we went on the record, and Mr. Polderman
Volcanic eruption. I'm really getting behind this.
called Mr. Doherty to the stand. I would have wanted to advise Mr. Doherty that he had a right in a criminal contempt proceeding not to incriminate himself, but he screamed on the way up to the stand about not having notice, indicating that he didn't mind testifying. I couldn't get him to sit in a witness stand and be quiet so that I could even advise him that he had a Fifth Amendment right against self-incrimination. Even if he did wish to waive it, I would have wanted to at least tell him that, but he screamed in my face instead and made it impossible to conduct a proceeding or to record a proceeding as we are required to do. That said, I think that the sentence he received was well-deserved. One of the purposes behind a criminal sentence is rehabilitation and making sure that the offender does not reoffend. I am not willing to go back at this time and start this anew with the allegations that were previously brought by the receiver. What I would like to do is go forward in the hope that Mr. Doherty can take part in all the proceedings in a way that's appropriate and allows the court to conduct proceedings. I also would note that there are some procedures in place now so that Mr. Doherty cannot send 10 emails a day to all of court staff, harassing and annoying and frightening them. And instead, he has a dedicated email through which he may communicate any legitimate business that he needs to bring before the court, and that will be always monitored. He also has an order in place that's been in place that he's not to harass various different people or have contact with various different people in this case, and that order remains in effect. So I would like to go forward with those safeguards in place, and that is my ruling, Mr. Doherty. I've made my ruling. And so I'm denying the receiver's motion to set a renewed date and time for the contempt. And Mr. Polderman, could you just do an order that indicates it's denied?
Yes, Your Honor, thank you.
Okay, thank you. That will end this proceeding.
Oh, good Lord. Okay.
We'll get the court.
That was good, Alyssa. However, now me and I'm sure everybody else wants to see the original volcanic eruption. But he was a tremendous a-hole. I'll give you that.
Date in the mail, Judge?
Yes, sir.
All right. Thank you very much.
Thank you.
Meanwhile, while we're doing that, back to Eric Martin here. While we're doing that, we've got his brother. Let me see. I'm in the way right now. Let me show you. Kurt Martin. And I get this nugget from I had to record it during it, so it's going to have some stupid audio, but I got this nugget.
Asking you once again, Your Honor, which
There's a little screenshot of Kurt Martin weighing in. If any of you ladies are interested, just know that the offer is out there now. Okay, that's Kurt. Okay, and then this is Eric. I know, it's tempting.
Judge, is anybody there? Hello? Oh.
Just wait. This is People versus Bennett Kerr. People versus Kerr. Case 34-.
By the way, I apologize. This is a little scattered, but this stuff is breaking midstream here.
3393FY.
Good afternoon, Your Honor. James Kazicki on behalf of Mr. Kerr. Waive reading of the complaint, stand mute, request a personal bond and court-appointed attorney.
Hi, and would you identify yourself, sir? You're on mute.
Your Honor, can you hear me now, sir?
I can hear you now, Mr. Kerr.
Your Honor, I am Bennett Bernard Kerr.
All right. Yeah, so this is an arraignment on the charge of possession of analogs. So I'm entering a not guilty plea.
Yes, sir.
scheduling your case for a pretrial conference. And
Give it time.
we'll give you notification of that. It'll be mailed to your address. Are you still on Ricky Lane?
Yes, Your Honor.
All right. So, yeah, your bond conditions, I'll give you a personal bond.
Thank you, Your Honor.
It's a felony, so it's gonna be a probable cause conference.
Oh, okay, it's a felony. All right, yep, your probable cause, we're gonna schedule you for a probable cause conference. It's going to be
February 3rd at 1:30.
February 3rd at 1:30, and we're going to schedule an exam as well, and that's going to be
February 10th at 2 o'clock.
February 10th at 2 p.m.
Okay, should I be writing this down or are you gonna send me a letter?
You can write them down.
Okay, one moment, please. Okay, the first date and time, please.
February 3rd.
February 3rd. At what
And
time?
that'll be by Zoom.
Okay, Zoom at what time?
And this-
1 o'clock?
1:30.
Schomburg in the house.
1:30. Okay, yes, Your Honor.
And the second hearing is February 10th at 2 p.m. And that's an examination, and that's in person.
February 10th. At what time, sir?
2 p.m.
2 p.m. at court.
Really?
Okay. Is there, Your Honor, is there anything I need to, well, I guess that would be, I'm sorry. Forgive me, Your Honor.
Okay, I'm giving you a $2,000 personal bond. The bond conditions are to come to court when you're required. Don't violate laws or ordinances. Advise the court of any change of address or telephone number. You're not to possess or consume alcohol or illegal controlled substances.
Yes, Your Honor.
All right. And you also need to go to the Taylor Police Department for fingerprinting. Actually, the Michigan State Police post for fingerprinting.
Really?
Yes, sir.
Yeah, really.
Within the next 7 days, before that probable cause conference, the Michigan State Police Station for fingerprinting. There's one on Telegraph Road in the city of Taylor.
Yeah, that's, yes, Your Honor. I'm confused because I'm on SOAR. They have all my prints. They lose them?
I don't know. You need to go there and straighten that out, though. If they don't need your prints, then you're all set, but I'm ordering you to do that within 7 days.
No, yes, sir, Your Honor.
All right. Any other thing? Anything
You
else?
said my bond is, it's supposed to be a personal bond?
It's a $2,000 personal bond, correct?
So what does that mean? I owe you $2,000? I don't have that.
If you violate the bond conditions, you would owe it to the court. You don't have to pay it today. But if you violate, you owe it to the court. So if you don't go to the state police station and get your fingerprints taken, then you could owe that to the court. If you don't show up in court when you're supposed to, you would owe that $2,000. If you don't otherwise comply with probation, you would owe that money.
I understand, Your Honor. Can I go today and do the fingerprinting?
Sure. Call them beforehand, make sure they can do it, but yeah.
Okay.
All right.
Thank you.
Okay. Thank you. So you're free to hang up then.
Okay. Have a great day, Your Honor.
You have a good one.
My God.
Officer,
And remember,
asking
lady,
you once again, Your Honor,
remember,
which I
you want to get in on this before he's all booked up. Okay. This is just my PSA here at Law Talk with Mike. There he is. There he is. It's all this right here is all Zach's fault. Just so you know. Just so you know.
have with you.
Your Honor, this would be Jeremiah
This here is also Alyssa's fault.
Brian Arnold.
Thank you. This is State of Kansas versus Jeremiah Brian Arnold, case number CLW 2024 CR 105. In this case, Mr. Arnold appears in person in custody by Zoom, and State appears by Ian Oddie, who appears by Zoom. This matter comes on for first appearance after a arrest on an affidavit of violation of probation filed by Court Services Officer Ashley Kling. Mr. Arnold, the affidavit filed by Ms. Kling asserts that on September 25th, 2025, you were granted 1 year probation from a sentence of 6 months in the county jail, that you served a 2-day quick dip sanction on December 17th, 2024 for failing a UA on November 21st, and that the UA was confirmed positive for amphetamines and methamphetamines. And then it asserts a new violation, which was violation of condition number 8, that you not illegally possess or traffic in any controlled substances. The allegation by Ms. Kling is that you submitted 2 UAs on December 17th and January 10th of this year, and that both were confirmed positive for amphetamine and methamphetamines. Do you understand the allegations in the affidavit of violation of probation?
Yes, sir.
Because you could be sentenced to serve a sanction which could be as great as, in order for you to serve the 126 days that remained on the sentence after your quick dip, you're entitled to have an attorney represent you in this case. That is a right you can waive. You can also ask for time to hire an attorney of your own choosing, or you could ask the court to appoint an attorney to represent you in this case. Do you know what you want to do regarding your right to an attorney?
I don't really want an attorney right now. The only thing I want is the option to go home and go get the thing that would prove that I was dose boss. And I figured out how. I just didn't figure it out until late.
Well, if
I would like an option to, look at my
if you're going to deny the allegations of the probation pro se, we're going to end up having an evidentiary.
He was what? Dose bossed is what I heard, but that makes no sense to me. That makes 0 sense to me. But I'm not on meth.
Hearing on that, you will be in custody until we can have that evidentiary hearing.
I'm not trying to
Do we have a meth translator in the house?
deny that I'm fully telling you, yeah, I probably was in fact had methamphetamines in my system. I just didn't know why.
You probably need to be talking to an attorney about that. But in any event, if you choose not to have an attorney, you will still have an evidentiary hearing at that, at which you can choose to explain to the court why you either aren't that you didn't intentionally violate the terms and conditions of your probation, and or present evidence on why the court should impose a sanction.
That's what he meant. Okay.
Less than ordering you to serve.
I mean, I don't believe it, but now that makes sense.
The remaining balance of the sentence. Do you want an attorney to represent you in that process?
I don't need an attorney. I just need to be able to, do what you just got through saying.
Oh, you need an attorney. You need to shut up. You need to stop taking meth. Pretty much in that order.
You understand if I appoint an attorney to represent you, well, if I were to appoint an attorney to represent you at the evidentiary hearing, which would take place in your presence in open court, the state would put on evidence to try to show by a preponderance of the evidence that you violated the terms and conditions of your probation, and either you on your own or through an attorney would have the right to cross-examine the state's witnesses. You would have the right through yourself or that attorney to present evidence on your own behalf if you chose to do so. And you would also have the right to testify on your own behalf, but you would not be required to do so. And if you chose not to testify, that decision would not be used against you in determining whether you violated the terms and conditions of your probation. You understand all those rights that you would be giving up if you proceed to a hearing without an attorney?
Yeah, I'm pretty sure I get that.
And is it still your desire to do that?
Yes, sir.
Very well.
I'm pretty sure you can't, because I did see the rest of this hearing, but it's really fun to see him try.
For the record, do you deny that you violated the terms and conditions of your probation?
I unknowingly denied. Yeah, I would say that.
Thank you. Mr. Audie, what would you like to do about scheduling a evidentiary hearing? I'm going to find that Mr. Arnold.
Don't worry, it gets worse. In fact, it gets spicy, and spicy in a way that you would never suspect.
Has knowingly waived his right to counsel at this time, and that we can proceed to schedule the matter for an evidentiary hearing.
I guess we just need to find a date on the calendar.
I'm looking at my calendar next week. Do you want to try to find a date next week?
Anxiety leads to constipation.
My calendar would load. There it goes. Looks like probably the only time I could do next week would be Tuesday morning.
Okay, Tuesday morning, I'm going to be in court in Kansas City. So if we go to the week after that, I'm going to be tied up Monday and Tuesday with CJE, but could be available, it looks like, any other day that would work for you.
Kristen, are you on?
Yes.
Do you have what the translator docket looks like on the 6th?
We have 1, 2, 3, 5 at 9, and then there's a care and treatment at 11.
Okay.
Are you involved in AOT at all, Ian?
Yes. Or no, not AOT. So that's what I was about to ask. What does the afternoon look like?
He has AOT that day, so he doesn't have court until 3:30.
Okay, could we do like a 1:30 on this then?
on February 6th.
Yeah.
That will work for the court, so we'll set this for an evidentiary hearing on February 6th at 1:30 p.m. That will be in person.
Sir, may I be let out so that I can get my evidence?
Mr. Audi, what's the state's position on a bond?
I need to pull up I don't have a copy of the affidavit, so I need to pull that up to look at it real fast.
I'm not even asking for the entire time, just this afternoon. I'll be back by 5. Latest.
Your Honor, I would ask that the defendant remain in custody. I'm looking at email I had from the probation officer, and the recommendation from her is a 45-day sanction in jail. So I would ask that he remain in custody.
I looked at the documents that accompany the affidavit, and they show positives both times with cutoffs of not less than that it has to be 500 nanograms or more for amphetamines, and you have the 2 prior positive tests, and I'm going to order that you remain in custody without bond until February 6th at 1:30 p.m. when we will have an evidentiary hearing on the petition, on the probable cause affidavit. Anything else we need to address?
Yes, sir. How am I supposed to gather my evidence?
Well, you could ask me to appoint an attorney to represent you, but that's not going to change your bond. It just change who might be able to help you in that regard.
My evidence is in my apartment locked away. I mean, literally, I am asking for a couple hours to go there and come right back, Your Honor. You can have a black and white, go with me. I don't care. I just need to pick up 5 bottles of seasoning.
Well, I'm not in a position to tell black and white that they have to go
I
with you.
understand that. I'm just asking for something reasonable.
Well, I can't really ask you what it is you think would prove that either the tests were wrong or that there's a reason why you tested positive without having known you were ingesting or injecting or inhaling or otherwise introducing controlled substances into the human body. So
I'm trying to be as honest as I can be and tell you if I were to go get the evidence and bring it back, then you would understand. I didn't. Took me.
Mr. Audi, I don't see a persuasive reason to allow him out so that he can
Cooking with meth.
violate probation again. What's your position?
Yep, that's his defense.
I
Telling you, gentlemen, I will be back here before 5 o'clock today. I won't even have time to violate.
like used to. I can't imagine like the allegation is positive for amphetamine and methamphetamine. I can't imagine what seasonings he could have that would establish that that's not true.
Somebody put them in my seasonings. I wasn't using seasonings enough to, get high on them. I was using them to spice my foods.
Well, that's an argument you can present to the court on,
But I can't prove it if I don't have the seasonings.
This guy really thinks he's gonna go home, get a few things of seasonings that test positive for meth, and everyone's gonna be like, "Oh my god, what a victim!" I'm sorry, sir. You can go right now.
I'm not going to release you on bond.
Yeah, no.
So,
Okay. You.
that concludes this hearing. I've made my order.
Okay, that'd be a no.
40? Good count.
Officer, who do you have with you?
This is Joshua Dion Sievert.
Thank you. This is the state of Kansas versus Joshua Dion Sievert, case number CLW 2025 CR 17. In this case, Mr. Sievert appears in person in custody by Zoom, and state appears by Ian Audie, who appears by Zoom. This matter comes on for first appearance on a 5-count complaint. Mr. Sievert, do you have a copy of that complaint in front of you?
Yes.
Does your correct name appear on that complaint?
Yup. Yes, sir.
Is it correctly spelled?
Yes, it is.
I'm going to go over the 5 counts in the complaint so that you know what you're charged with and the possible penalties that could be imposed.
Don't worry, this guy's got a defense just as good as the last guy. It's not seasonings. It might involve the high dive.
If you were convicted on one or more of those 5 offenses. Count 1 alleges that on January 15, 2025 in Kelly County, Kansas, that you intentionally and knowingly possessed a controlled substance being methamphetamine, that is known as unlawful possession of methamphetamine. It is a severity level 5 drug felony. That is an offense for which, if convicted, you could be sentenced to the custody of the Kansas Department of Corrections for a minimum of 10 months to a maximum of 42 months. You would also be subject to a possible fine of up to $100,000, and you would be subject to post-release supervision for a period of 12 months. Count 2 alleges that on January 15, 2025 in Kelly County, Kansas, that you did, with the intent to defraud, issue or deliver a written instrument, being a check, knowing that that check had been made, altered, or endorsed in such a manner that it purported to have been made, altered, or endorsed by an individual who did not authorize the making, altering, or endorsing of that check. That's known as forgery. It is a severity level 8 non-person felony. That is an offense for which, if convicted, you could be sentenced to a minimum of 7 months to a maximum of 23 months in the custody of the Kansas Department of Corrections. You would be subject to a possible fine of up to $100,000, and you would be subject to post-release supervision for a period of 12 months. Count 3 alleges that on January 15, 2025 in Kelly County, Kansas, that you knowingly obstructed, resisted, or opposed a person you knew or should have known to be a law enforcement officer, being Officer Kelsey Hornick, and that Kelsey Hornick was authorized by law to perform an official duty, and that your act, being to give a false name, substantially hindered or increased the burden of Officer Hornick in the performance of her official duty. That's known
Don't worry, he eventually talks.
as interference with law enforcement, obstruction of official duty. It is a Class A non-person misdemeanor. That is an offense for which, if convicted, you could be sentenced to up to 1 year in the county jail and fined up to $2,500. Count 4 alleges that on January 15, 2025 in Cowley County, Kansas, that you intentionally and knowingly possessed, used, or had under your control with the intent to use drug paraphernalia, being a baggie used to store, contain, or conceal a controlled substance that is known as possession of drug paraphernalia. It is a Class B non-person misdemeanor, and that is an offense for which, if convicted, you could be sentenced to up to 6 months in the county jail and fined up to $1,000. And count 5 alleges that on January 15, 2025 in Cowley County, Kansas, that you committed an overt act towards the perpetration of the crime of theft by deception, being that you attempted to obtain unauthorized control over property worth less than $1,500, being United States currency valued at $450, and you did so by means of a false statement or representation which deceived Union State Bank, who relied in whole or in part upon the false representation or statement made by you, and that you did so with the intent to permanently deprive the owner of the possession, use, or benefit of that $450, but that you failed in the perpetration of that offense, or were prevented or intercepted in completing that crime. That's known as attempted theft by deception. It is a Class B non-person misdemeanor. That is an offense for which, if convicted, you could be sentenced to up to 6 months in the county jail and fined up to $1,000. Do you understand each of those 5 offenses and the possible penalties that could be imposed if you were convicted on one or more of those charges?
Yes, Your Honor. I haven't even got a chance to really fill out for a attorney yet, but I was wondering if I could possibly get recommended with Jennifer Pasilga, because I was really wanting to try to get the drug court program, because I really wanted to get help with.
I understand that, but
Okay, this guy's lost his mind completely, and he's still 2 steps above the last defendant because he realizes he needs an attorney.
that's what I was going to address next in the process. You do have a right to have an attorney. You can waive that right and represent yourself. You could ask for time to hire an attorney, or you could ask me to appoint an attorney, and if you're found to be eligible for court-appointed attorney services, I would appoint an attorney to represent you. So, are you presently employed?
No.
When's the last time you were employed?
It would have been last year, about September, by the time I moved. And then came out here. I mean, honestly, I'm not gonna lie, you guys. Like, I mean, I can get it. As long as I get my act right, and if I stay sober, I have a job for Taco Bell. Crystal Morgan already told me as long as I stay clean, she'd give me a job at Taco Bell. But it's just a matter of staying clean and being clean. I realized like I do have my drug problem, you know. Coming here wasn't the greatest idea for that drug problem, but if I just know like if I'm able to get that drug order,
Yeah, it's Kansas's fault. If he would have chosen another state, he'd be fine right now. And of course, yeah, the irony of he later says he wants to go work for Crystal, which, you know, I think is true.
I'm going to find that you're eligible for court-appointed attorney services, but I have to check what rotation I'm in on appointing an attorney.
Judge, he did previously have Giles.
Okay, that's actually who I landed on. I'm going to appoint Chad Giles to represent you in this case. He is an attorney officed out of Arkansas City who takes court appointments. And he will be given an order of appointment and material so that he can prepare to represent you in this case. Officer, is there a bond set in this case?
I show a bond set at $5,500.
Your Honor. I was actually about to talk to you guys about this bond thing. I do have my dog that's been staying at my friend's house.
Mr. Audie, do you see any reason to modify the bond in this case?
I was just curious, like, if we're gonna be possible about maybe, because if I can get, I was just gonna say, if I can get out and start working for Crystal, so I can start making money for the hopefully get the drug court program.
Let me hear from Mr. Audie.
Okay.
Judge, I got a puppy to take care of. So just let me get out and start working for Crystal.
I would not object to a bond reduction. I would ask that it remain a surety bond, though.
Very well. I'm going to reduce the bond to $2,500. That will have to be in the form of cash or professional surety. Mr. Sievert, if you're able to make bond, it will be a condition of your bond that you immediately contact Mr. Giles' office, provide them with contact information where they can get hold of you and meet with Mr. Giles as and when he may direct, and then that you'll be back here for the next court appearance, which will be a Zoom appearance, and I'm going to set that next court date for February 5th.
You have to say, ooh, Mr. Carter.
At 9 a.m. That will be a Zoom hearing before this
is done.
court. And it will be for selection of a preliminary hearing date. Any question about what I've just done?
Okay, so my brain's, back when I was 11, I had a high dive accident and it's causing my brain to kind of deteriorate. So I am going to ask a couple of questions here because I don't understand some things, clearly. So, okay, so the bond is $250 now?
The bond is $2,500, cash or professional surety. How much the bondsman charges is between you and the bondsman.
Okay. I was gonna say, because I really don't have the money to bond yet, but I was really trying to get out and start working for Crystal. I was really kind of asking for the OR bond, but and whatnot, because I really got to worry about my puppy too. Because I know my friends.
I've made my decision on bond, and you're repeating stuff that I heard before I made that decision. I think it's appropriate to have a professional surety bond to make sure that you appear.
That's understandable.
And if you're able to make bond, contact Mr. Giles and be back here on Mr. Giles' office and be back here on February 5th at 9 a.m. If you're not able to make bond at that time, we will address scheduling matters and Mr. Giles will help you address any further possible modification of bond at that time.
Right. And then would there be any chances of possibly like getting onto the drug court program so I can get help?
That's something that you need to be talking to Mr. Giles about.
Well, okay. Do you know how long that would be before he would come to see me or anything? Or Because I really do like.
I don't control his docket or his schedule. What I do is make an order appointing him and setting the matter for February 5th at 9 a.m.
Okay, yeah, because I mean, I would actually really like to get some help. You know.
Okay, well, that's something you need to discuss with Mr. Giles when he fits you into his schedule.
Okay.
If there's nothing else, that concludes this case.
All right. I got a 5-minute gap I'm going to fill for Big in here. That's what we're going to do. And I got just this thing for it.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax, maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all, please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for this whole thing. He clearly has no idea what he's doing, so sit back, relax, and maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. Attention, esteemed viewers. If you are hearing this message, it means that you...
There is no schedule at Law Talk Nation. You can only pray, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Planning always make your chap smile. The pro se can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons